American people. Mr. President, my people are on the sea.
I will place economic stability and confidence.
What propagandists are property. Would you like to leave of this minister and the propaganda?
Good morning and welcome to Open Conversation on Atlantic Television Network. Open Conversation is the network's flagship political platform through which trending political news, events and stories are discussed with stakeholders. Through these conversations, ATN uses political talks about specific issues, party system and actor to explore hope and engender positive impacts to the society. Today on Open Conversation, we'll look at two Rivers stories on Rivers crisis. Appeal Court affirms Amehule as Speaker, voids 2024 budget. And on the second story, government insists lawmakers' seats remain vacant. We'll go on a short break. When we come back, we'll delve right into the show. Tonight.
I've always said there are two sets of people, the oppressors and the oppressed, and in between are the coward and the hypocrites, which I am.
No matter how tough the challenge, how high the obstacles, we always overcome.
What Nigerians believe now is not about the company. Who can come and salvage us from where we are?
The people of Maiduguri need your help. A catastrophic flood has engulfed the city, leaving over 1 million residents stranded and fighting for survival. Entire communities are submerged, with people trapped inside homes and on rooftops cut off from food, clean drinking water and essential supplies. Health experts are warning of a potential outbreak of deadly diseases, and medical facilities are out of commission. The situation is dire. Helicopters, boats and high-riding trucks capable of navigating the treacherous, waterlogged areas are urgently required to reach the countless men, women and children still awaiting rescue. The Nigerian media is issuing a desperate plea to the government, humanitarian organizations, international actors and citizens across the nation. Step in now, before it's too late. For more information on how you can help, contact Professor Usman A. Tar, the Honorable Commissioner for Information and Internal Security, Borno State, on 0809-233-3955. Every second counts.
This is powered by Atlantic Television Network.
From the lines across the ocean to the land beyond the mountains, through the Sahara, we bring all the sport news, live analysis, expert discussions on trending stories in politics, business, socio-economic, sports, and documentaries. So catch all the updates on the happenings around the globe. Stay focused on the fact today. Only on ATN.
Representing people. Mr. President, my people are on the sea.
I will place economic stability and confidence.
To condemn this act, I call for critical belief of this minister and the government.
Give us access to our money.
I've always said there are two sides of people, the oppressors and the oppressed, and in between are the coward and the hypocrites, which I am.
No matter how tough the challenge, how high the obstacles, we always overcome.
What Nigerians believe now is not about the government. Who can come and salvage us from where we are?
Representing people. Mr. President, my people are on the sea.
I will place economic stability and confidence.
To condemn this act, I call for critical belief of this minister and the government.
Give us access to our money.
I've always said there are two sides of people, the oppressors and the oppressed, and in between are the coward and the hypocrites, which I am.
No matter how tough the challenge, how high the obstacles, we always overcome.
What Nigerians believe now is not about the government. Who can come and salvage us from where we are?
Representing people. Mr. President, my people are on the sea.
I will place economic stability and confidence.
To condemn this act, I call for critical belief of this minister and the government.
Give us access to our money.
I've always said there are two sides of people, the oppressors and the oppressed, and in between are the coward and the hypocrites, which I
how tough the challenge, how high the obstacles, we always overcome.
What Nigerians believe now is not about young people who can come and salvage us from where we are.
Representing people, Mr. President.
Welcome back and thank you for staying with us. Joining me on Open Conversation this morning is Ndamze Ekulo ESQ. Ndamze Ekulo is a lawyer and conflict resolution expert. Good morning, Ndamze.
Good morning, Laurentia. Good morning, Council. Good morning, viewers.
And also joining me on Open Conversation is Barrister Living Gifting Jamala, a legal practitioner and a political analyst. Good morning, Barrister Living.
Good morning, Choma. Good morning to our esteemed viewers. Good morning, Senior Counsel.
All right, and on to the story. Court of Appeal sitting in Abuja on Thursday affirmed Honorable Martin Amehule as the authentic Speaker of the Rivers State House of Assembly. The appellate court, in a unanimous decision by a 3-member panel of justices, equally validated the Amehule-led members of the Assembly as bona fide lawmakers for the state. While dismissing an appeal that was lodged before it by Governor Similaye Fubara, the court upheld a judgment the Federal High Court delivered on January 22, which nullified the 2024 budget of Rivers State on the premise that it was not presented before members of the State Assembly that were known to the law. According to the appellate court, Fubara shot himself on the foot when he voluntarily withdrew a counter-affidavit he filed to challenge a legal action the Martin Amehule-led lawmakers instituted to be recognized as valid members of the Rivers State House of Assembly. The court held that Governor Fubara's decision to present the 2024 Rivers State Appropriation Bill to only 4 out of 31 members of the Assembly amounted to a gross violation of Section 91 of the 1999 Constitution as amended. It will be recalled that the Rivers State Assembly was factionalized owing to the frosty relationship between Governor Fubara and his predecessor and Minister of the Federal Capital Territory, Nyesom Wike. In the heat of the fracas, Governor Fubara sidelined the Amehule-led 26 members of the House that were loyal to Wike and presented the state's 800 billion naira budget, 2024 budget, before the 4 lawmakers led by Honorable Edison Ehe, who had emerged as a factional Speaker of the Assembly. The Ehe-led faction, which had also declared the seats of the Amehule-led lawmakers vacant for defecting to the All Progressive Congress from the People's Democratic Party, promptly passed the budget, which was quickly assented to by Governor Fubara. Meanwhile, following the intervention of President Bola Tinubu, both Fubara and order of injunction restraining Governor Fubara from impeding or frustrating the operations of the Assembly under Amehule's leadership as his Speaker. It ordered the governor to release all funds standing to the credit of the Rivers State House of Assembly. While upholding the verdict of the lower court, the appellate court held that Fubara conceded to the Amehule-led lawmakers when he withdrew all the processes he filed against their suits. A party must be consistent in the presentation of its case. A party cannot approbate and reprobate or blow hot and cold at the same time, the appellate court held. Unanimously, all the 3 judges of the Court of Appeal agreed with Justice Omotosho's judgment, recognizing Martin Amehule as the authentic Speaker of the Rivers State House of Assembly. The court insisted that the appellant, Governor of Rivers State, treated the court order with disdain, adding that the quorum of the House of Assembly shall be 1/3 of its member and 4 out of 30 cannot form a quorum. The court said, democracy is anchored on the rule of law and not rule of might, as seen in the action of the governor of Rivers State. And according to the judgment, all expenditure done by Rivers State's governor without the appropriation of Right Honorable Martin Amehule is illegal to the extent of its expenditures. By this judgment, all laws made by the Rivers State House of Assembly led by Martin Amehule, including the extension of tenure of the local government chairman, remains valid. It held that the orders of the trial court were appropriate given the circumstance of the case, saying the appeal Fubara filed before it amounted to an academic exercise. According CA/ABJ/CV/133/2024. Let me start with you, Jamala.
Why are you starting?
So am I starting with you?
Yeah, just wondering why you.
I am really interested to know what you
what's
have
on my mind.
Yes, what's on your mind, Jamala? I mean, both you and Ndamzi have been regular on my show, particularly with respect to River State's issues when it has to do with legal tussle. I always love to hear you and Ndamzi, and I would want to start with you, Jamala. What do you make of this development?
My position is nothing strange to what the press release given by the Honorable Attorney General of River State. I'm not holding brief for him, but I speak to my understanding of the law and as the facts unfold. Yes, your preamble stated it very well, or your excerpt stated very well, to the extent that, yes, there was an appeal, there was a proceeding that pended before my Lord Honorable Justice Omotocho, and in January, another was given, a judgment was given to the effect, as you have so far stated. I will not want to go into the legalese of why should the defendant, governor's lawyer, withdraw their own product for the defendant to have withdrawn his process. The processes you filed challenging the allegations leveled against you. Those allegations are still existing, but you have withdrawn your, in other words, admitting. It was a landmine prepared for them, and they unknowingly, going to the directive of Mr. President, fell into it. But that is for another day. Let's look at the judgment as came yesterday. With all due respect to my Lord, the Honorable Justices of the Court of Appeal, that is their position, is not final. Remember, there is right of appeal to the Supreme Court. But assuming you have the records, if you do so.
Earlier this year.
Yes. December. Okay, December, right? Now, this suit was instituted sometimes around October, November, and judgment given in January.
So how come the judgment included legitimizing them?
It did not legitimate. No, it did not. The judgment,
as the authentic speaker
no,
of
the judgment did not determine the question as to defection, whether their defection was right or not. You remember? It only talks about, in the eyes of the law, looking at whether they are members of the assembly and the governor is bound by law to relate with them. It has nothing to do with defection. The issue as to how Edison came up, the Edison and Jumbo came up, was upon the declaration of a court order, ex parte, directing them, recognizing them as the authentic House of Assembly members in River State, prohibiting some set of persons from functioning. That was when the budget of 2024 was presented to. So there are two different games. Yes, there are two different games playing out. Yes, the judgment of the Court of Appeal yesterday stands with law. Because in law, when there are no controverting evidence, when there are evidence placed by party A, is not controverted by party B, the court is bound to accept those arguments. Unless it is obvious to the court there are some certain things that is against the principles, maybe party A wants to misdirect the mind of the court over an existing known issues of law, then the court can direct its mind. But the court is bound. The Evidence Act is that there are pretorial authorities to that effect. So yes, it is true. The governor and the team of the governor shot themselves in the foot when they withdrew those applications. That's right. But to what extent is the judgment? Because I am of a view that is also an academic exercise. By the governor? No. The judgment as of yesterday,
by the appeal court was a mere academic exercise.
The judgment is specifically with reference to the appropriation law.
Why do you say it's a mere academic exercise?
This is November. This is October. Appropriation law is meant to serve till December, and if for some certain reasons the assembly, the governor is not able to make another budget passed by the assembly, extended up to a period of 6 months. Now, Some of those expenditures has been carried out. Salaries have been paid to workers out of it. Projects have been executed out of it. Declarative reliefs to undo an act that has been done is an academic exercise.
All right. Do you recall when the budget was presented to Edison here?
Yes, I do.
What month was that?
That was late December.
December.
Late December, yes.
And
December.
January.
Yes.
Because it's a full cycle budget.
Yes.
Now, January 22nd, there was a judgment.
Yes.
And in that judgment, the governor was ordered
yes.
to represent...
That was not a final decision.
Hold on.
Okay.
The governor was ordered by Justice Omotosho to represent the budget. First of all, the judge nullified the presentation of the 2024 appropriation bill to Edison Ehe, led House of Assembly, and the judge ordered the governor to represent the budget to Martin Amehule, led House of Assembly. If I may ask, did the governor appeal that matter?
That is the judgment that came up yesterday.
Hold on. There was a judgment in January.
Yes, Omotosho's judgment.
That judgment, part of that judgment, because a lot of things were,
yes.
a lot of prayers were granted.
Yes.
Part of the prayers that was granted
yes.
in that judgment was ordering the governor to represent the budget. Now, you are saying that it's a mere academic exercise. I mean, the judgment, yes, there was a mere academic exercise because the lifespan of that budget is almost expended.
Yes.
However, I'm bringing you back to January.
Yes.
That
when the judgment was given.
Yes.
Can I answer that?
Hold on. That when the lifespan of this budget barely started,
yes,
that a judge gave a judgment and ordered the governor to represent the appropriation bill. So how do you call that also an academic exercise?
I'm coming. When a judgment is given and you are appealing against that judgment,
did the governor appeal it?
That is the judgment that came.
It
is that appeal. Yes, this appeal for judgment of yesterday.
When was it appealed?
I wouldn't know where they filed, but the judgment came up yesterday. That is the judgment of Omotosho.
Now the question is,
let me
when
answer.
was it appealed?
It was appealed within the time allowed by law by a party to appeal. That was why the judgment came yesterday. Now, I'm saying that when a judgment is given, and it's against you, are dissatisfied with that judgment, and you appeal, and you have also made the necessary processes in staying those execution, and you are allowed to, Shoma, if you go ahead acting as though that judgment never existed, it can never be reckoned against you in the eyes of the law.
Did the governor get a stay of execution of that
whether
judgment?
Whether the government, I cannot.
They did not. I am clarifying you on that.
You and I can't say so.
I can't say so. I can say so because I do my investigation. There was no stay. No. There was no stay of execution of that judgment. The second question I want to ask you, Barrister Jamala.
Are you imposing it on me?
No, you're saying you don't know, and I'm clarifying you. You're telling me I cannot say so. I can say so because I'm telling you a statement of
facts. Supposing I bring a superior argument as to the fact that
you have to bring evidence.
Yes.
But you just said now, Barrister Jamala.
I don't want to be
specific. Using your word. I am using your word.
Yes, I said I don't know to the extent that I do not have that valid application.
Well, I am telling you.
Okay.
Now, secondly, Barrister Jamala, the governor appealed the judgment of Justice Omotosho.
Yes.
Very quickly, before I come to Ndamze, the governor appealed the judgment of Justice Omotosho. Now, the question would be, the governor or the government of Rivers State in the first instance withdrew their defense or their application, whatever legal.
Counter affidavit, address in
now,
opposition
by that
papers.
particular action, they have completely removed themselves from that matter. And in face of lack of defense or any counter applications, the judge gave a judgment. If the governor and the government of Rivers State have removed themselves from a matter, which means they are not party to that case, what is the locus?
They are parties in time. Even at the Court of Appeal has the right to raise issues of jurisdiction. Although you have withdrawn your processes at the lower court and judgment is given, you can challenge the jurisdiction of the court, even up to the Supreme Court. So if that was never presented before the Court of Appeal, You are even placing me on a position to give the legal team freely pro bono advice. They can challenge the jurisdiction of court. Budget is a state law. And it is not the federal government, it is not the federal high court that has jurisdiction to determine on state laws. It is the state high court. And so for every action, there are the suit brought before Ameul Omotosho muzzled so many state issues and national issues. Issues that have to do with the National Assembly, Section 92, giving Section 92 and 91, giving jurisdiction to the Federal High Court.
Jamala, you're pushing me back to remind you of something you said that is contradicting your statement now with regards to jurisdiction. Because now I'm beginning to wonder. I'm beginning to hold on, Jamala. I'm beginning to wonder. I will tell you. Because I'm beginning to wonder if the law is subject to interpretation depending on your mood. Now, you recall. Jamala, you recall that when we were having conversation around the issue of RISEC and the litigation, right? And APP went to court with respect to RISEC, the elections. And the State High Court now gave RISEC instruction to go ahead with a document belonging to a federal institution, and the State High Court as well ordered a federal institution to participate in the election. And you were of the opinion that the State High Court had jurisdiction to give that order because the matter was state related.
Has this changed in the circumstance?
But then
that opinion
it still boils down to jurisdiction of the federal and the state.
I'm coming as my jurisdictional explanation with respect to this circumstance changed from my
previous. Changed to
it has in maybe it's your understanding. It hasn't. I said the State High Court has the jurisdiction to interfere with national institutions so far as it relates with the activities of the state.
So why can't the federal interfere with the state institution as long as it relates to the matter of the State House of Assembly that the state does not have jurisdiction to entertain? We'll still come back to that. But
Section 251 is so clear about jurisdictions of court.
All right.
The Federal High Court cannot determine on River State-owned law.
But River State can give order to a federal institution.
So long as it relates with the activities of that state.
And in this instance, the River State House of Assembly and the appropriation bill is not directly related to the River State House of Assembly.
River State House of Assembly alone is not. Is River State House of Assembly?
So are you telling me in this instance that a State High Court can interfere in the matters of the State House of Assembly because of the budget?
A State High Court can question the procedure of lawmaking. The National Assembly, the Federal High Court can question the National Assembly with respect to their procedures, but it cannot interfere in how they go about.
Now,
but if the procedures is unknown to law, the court has a way, the court has the jurisdiction to direct its affairs.
In this instance, the appropriation bill and the procedures has to do with the State House of Assembly.
River State House of Assembly.
Which the State High Court does not have jurisdiction.
The State High Court has the jurisdiction.
Matters pertaining to State Houses of Assembly.
No.
Don't come to that.
Yeah, you're making it.
No, I'm not. It's simple.
Well, River State laws. Let me answer you. River State laws, as emanating from River State House of Assembly, it is the River State High Court that has the jurisdiction to interpret it.
Oh, hold on. I ask a simple question. Can the State House of Assembly entertain matters pertaining to, let me remove River State. Can State High Courts entertain matters pertaining to State Houses of Assembly?
Very well.
They have the jurisdiction.
Very well. They have the jurisdiction.
All right.
Yes. Very well.
All right. That's all I want to hear.
Thank you.
Now, Ndamzi, what do you make of this story?
Yes, thank you very much, Uma. I have listened keenly to my good friend and brother, Barrister Jamala, and I want to state emphatically that the Court of Appeal only re-echoed the position of the Constitution in giving that judgment because, one, it is right that when a party to a suit withdraws his or her matter as the matter is ongoing in court, you are invariably telling the court that you admit to all allegations and facts before the court. So just like he mentioned, that the governor's team shot themselves in the foot, and the Court of Appeal went ahead to re-echo it that it is irredeemable, even up to the point of Supreme Court. He knows he's a lawyer. Having withdrew that matter doesn't have life again, because the governor's team have inadvertently admitted all facts pleaded by the applicant at that stage. So that is that. Then on whether the Federal High Court originally should have assumed jurisdiction, the answer is yes. Because at the commencement of that trial, you can see parties to the suits. The National Assembly was a party. The police was a party. Rivers State government was a party in that suit. And if we borrow a leaf from the previous Court of Appeal judgment of the 27 House of Assembly members and Rivers State, the court assumed jurisdiction in that matter and went ahead to say that since it has to do with houses of assembly, that Federal High Court was right in assuming jurisdiction. So at this point, I do not, in my own view, I do not believe that it is a jurisdictional concern. It is no more a jurisdictional concern, but a pure legal concern. Legal concern in the sense that Professor Wendell Holmes made it clear in his position, even before the presentation of the budget by the governor to Edison Eye-led assembly, the order of Justice Omotosho had come. The order was very direct. Represent this budget to the assembly, Martin's Amehule-led assembly. The governor flagrantly disregarded the court order. And in that, I remember in that judgment also, the court recognized the speakership of Martins Amehule and the membership of other disputed assembly members. The court also, in its wisdom, went ahead and ordered that the governor shouldn't interfere with the legislative business of the House. The court went ahead also in criticizing the governor the governor transferring out of the assembly the clerk and the deputy clerk, because that is within the purview of the assembly. The governor has no right to interfere in legislative matters. So the Justice Omotosho Court haven't made these decisions. What the Court of Appeal only did was to uphold everything Omotosho said in its entirety. And I know my good friend Jamala will talk about what would have been the position of the law if in the event where, let's assume, Martins and Co. actually defected. You know, I remember one of the time I had an outing with him on the radio station. This was his position. And in that outing, I was very clear. I told the listening audience then that there is no way 4 House of Assembly members can embark on legislative transactions involving the entire state. Okay? Then now, if you look at section 96, sub 2 of the Constitution, it is very clear that in the event where quorum is lacking, the Speaker should adjourn the House indefinitely until whatever be the reason for quorum lacking is resolved. So, ordinarily, let's assume Martins and Co. actually defected, which the court have not said that they did. Never a time would the governor think that he would present a budget meant for expenditure of the entire state to 4 members of assembly. It is not lawful, and I thank God that the Court of Appeal have, dismissed that position and upheld the judgment of Justice Omotosho.
So can I now
Hold on, Jamala. Now, I want to ask you a question, Damzi, with regards to the governor appealing this matter. Now, the question I want to ask, like I asked Jamala, I'm still going to throw the same question to you. What does the governor have the locus to appeal that matter? Because let me break it down to my own layman understanding. Now, you have a case with someone, and you took the matter, or both of us have a case before the court. You took the matter to court, and I'm the respondent. And after a while, for whatever reason, I withdraw my own proceedings from court and show disinterest and never came to court again, and judgment was passed. By the reason of my withdrawal from that matter and removing myself from that matter and not raising any defense whatsoever. Now, is that not me abdicating, or is that not me waiving my rights? Is that not me waiving my rights?
Thank you.
If that is so, and the judge and the court gives judgment at the end of the day that does not favor me, do I have the right to start crying foul and probably run to a higher court to tell them to come and adjudicate on this matter that the lower court has dealt wrongly with me? When of a truth, when you look at the court proceedings, I waived my rights. So that's the question I'm asking. Does the governor or the Rivers State government in this instance have the locus to appeal the judgment of Justice Omotosho?
Thank you very much, Yoma. You can see even the Court of Appeal in their wisdom re-echoed it, and I'm going to say it again. It is right in law that you cannot reprobate and at the same time approbate. That matter died a natural death when the legal team of the governor withdrew the matter from the court. I say this and I stand to be corrected in any forum. Even the court have, posited that what the action of the governor is unknown to the law. Having withdrawn that matter from the Federal High Court, you are inadvertently telling the court that I have admitted all facts pleaded by the applicant. I am also withdrawing my allegations. Don't forget that the counter affidavit deposed by the governor's team, okay, contained allegations against Martins and co. So the governor's team haven't withdrew that allegation. Simply means you are telling the court, I am withdrawing my allegation, and everything the applicant said in his own affidavit is true. So inadvertently, the governor's team admitted all facts pleaded in the affidavit deposed by Martins and the 26 remaining House of Assembly members. So at this point, running to the Court of Appeal, when you willfully withdraw your matter, what do you expect the court to do for you? That is the question. That is the reason the court said that their action is completely unknown to the law. So, and I'm very, very confident that the Supreme Court will re-echo some same position.
Right.
Then also, before you ask another question or go to my friend Jamala,
all right,
I would want to say something. We shouldn't forget that the Federal High Court, led by the Federal High Court of Justice James Omotosho, was very emphatic in his judgment that Martin's speakership was never in contention. Okay? Then now, Court of Appeal have come to say we are upholding everything Omotosho held in his judgment. So, in the eyes of the law, Martins remained the authentic Speaker of the Rivers State House of Assembly, and the 27 others, in conjunction with Okojombo and others, are all valid members of the House of Assembly. So I will use this opportunity to advise the governor to appreciate that fact, allow this matter die a natural death.
All right.
Carry everybody along in the interest of peace in this state.
Right. We'll still come to that in our second story, so let's not preempt that. But the question I wanted to ask was a concern raised by Barrister Jamala. And I am asking you that question. Barrister Jamala said that Justice Omotocho, or Federal High Court in this instance, didn't have the jurisdiction. He questions the jurisdiction of the Federal High Court to entertain matters relating to the 2024 Rivers State budget. Now, his argument is premised on the fact that it is a state document. So now, if I may ask you, Ndamzi, can you throw more light on that?
Yes, on jurisdiction.
Yes.
Fine.
With regards to the circumstances of this matter, because I know that every matter is peculiar, the circumstances of the matter that was brought before Justice Omotosho in relation to the presentation of the 2024 appropriation bill by the governor to Edison Ehe-led faction of Rivers State House of Assembly as at that time. So I would want you to marry all the intricacies together and determine whether, according to the law, the Federal High Court in this instance had jurisdiction to entertain that matter.
Thank you very much. I want to state categorically, for the interest of the listening audience, and also to clarify this issue of jurisdiction as regards this matter. Do not forget, the dispute as have arisen wasn't just budget 2024 alone. There were already disputes before the issue of budget emanated. And the dispute began with the suspension of Edison and Co. by the Rivers State House of Assembly. That suspension was never lifted. That is the genesis of the crisis. Then the second phase of the crisis heated up when the governor made moves to remove Martins through the instrumentality of Edison and Co. That was when the crisis became very imminent in the House. Then now, before a lawyer files action in court, the first thing that comes to mind is the court I'm approaching. Does this court actually have the jurisdiction to hear this matter? Secondly, the parties to the suit. Who are the parties to the suit? Then thirdly, you not look at the general ingredients as pertaining the dispute or the course of action. Then now, in the case of the House of Assembly, do not forget that the Rivers State governor, when the crisis was heightened, Rivers State intended to renovate the building. They went ahead destroying the building and all that. When Martins and Co. filed to the Federal High Court, to maintain law and order, don't forget a federal agency must come in, which is the Nigerian police. Then at that point, there were rumors of National Assembly taking over the functions of the State House of Assembly as enshrined in Section 11 of the Constitution. So at that point, the National Assembly, which is a federal lawmaking entity, comes in. So there is no way any right-thinking lawyer would have filed in the High Court, considering that there are federal agencies involved and there is a federal entity also, Federal Legislative House is involved here. So parties must consider the Federal High Court as the court that has proper jurisdiction. That is why in the last judgment of the Court of Appeal before this one, the court was very clear and said Federal High Court had jurisdiction. So if it were to just be disputes surrounding budgetary concerns alone, we'll be looking at the proprietary or otherwise, or whether or not the State High Court had jurisdiction. But in this case had babies, branches that led to other federal concerns. So no way the State High Court would have had
and that issue cannot be treated in isolation.
The High Court, that issue
cannot be treated
in isolation.
Okay. Now, Jamala, what do you have to say? You've been itching to say something.
I admire this being evasive of the direct response. You asked him a very specific, direct, unambiguous question, which is to the fact that does the Federal High Court has jurisdiction to adjudicate over state laws.
And I also narrowed. Hold on. I also narrowed it down. I said considering.
So the budgets.
No, hold on.
Their action donate jurisdiction to a court. Yes, he talked about. If you're talking about parties, because there are national institutions that are attached to the suit, making them parties alone, gave them the court, clothes the court with jurisdiction.
To entertain that.
To entertain the matter with all sense of responsibility. I differ in that line of thought.
All right.
It is the states. Yes, the issues that has to do with state government relating with the House of Assembly. Section 92 is clear. 92, 91 is clear. Donating powers to the Federal High Court. It's very specific. And so a state House High Court cannot do so.
Cannot do what exactly?
Cannot legislate the issue of whether there is a seat is vacant in the State House of Assembly. So when the judgment of the expert,
you're limiting it. Is it that the State High Court cannot?
You
said with regards to
all the causes of actions. Let's severe all the issues.
Right. Okay.
There are issues that the Federal High Court is clothed with the jurisdiction to entertain.
Okay.
I agree. But the ones that the Federal High Court is not clothed with the jurisdiction, you cannot say those reliefs are ancillary.
All right.
That because I am clothed with the relief to do this, I'm clothed with jurisdiction
I'm joining this one into it.
And joining this one, that I do not have the jurisdiction to do so. That is not the law.
All right.
That is my point. He can go ahead if Omotosho ordinarily can determine whether the state government can relate with Amewule-led assembly, having been constituted, nothing is challenging.
He has the jurisdiction to legislate on that.
It is the powers of the it is the powers of the Federal High Court to do so.
Okay, to tell the governor to relate with so and so House of Assembly.
So, yes.
Okay, all right.
It is his powers to do so, but it's not his powers to determine whether the budget of a state is properly presented or not. It is not the powers to legislate whether the budget of a state is properly passed or not. That is the responsibility of a state high court.
Now, this is the issue now, Jamala.
I beg to differ.
All right.
Yes, I beg to differ because I think we are missing out a point here.
And that is?
The course of action was not premised on whether the budget was properly passed or not. The course of action was basically on whom the budget was presented to, the rightful speaker. Okay, and I and you know that when it comes to disputes on speakership of a House of Assembly in Nigeria, Federal High Court is saddled with that responsibility.
I agree, but
no, I want to clarify a position you just took.
Yes.
Okay. You said here that the State High Court had jurisdiction when it has to do basically on budget. But state we should laws. State laws. Yes. But budget we should yes, but we should clarify it properly for the interest of our viewers. The dispute, the course of action has arose then was not whether the budget was properly passed or not.
So if that was the
course of action was just simply whom was the budget presented to.
Yes.
Don't forget it has to do with the Speaker of the Rivers State House of Assembly.
Yes, if a
and the Speaker has the jurisdiction. The course of Federal High Court has jurisdiction when it has to do with
if the Federal High Court lacks the jurisdiction to entertain state law, why would the federal government, Federal High Court, has jurisdiction to abolish that same law that it lacks jurisdiction to entertain?
But we should not mislead the viewers.
We're not.
We should not mislead the viewers. We should not also digress. We should not also digress.
It's a very simple.
Here. I want to reiterate again.
Yes.
The position is very clear. The cause of action as arose in the House of Assembly. In fact, the cause of action as
misleading reports regarding the court's judgment and assured them that the legal steps are being taken to resolve the matter. So you cannot continue with your
Yes, I said the decision of the Court of Appeal yesterday has taken us back to sometimes in 2023. Thank God the date is clear, December 11th, where there was a defection. Prior to their defection, they had initiated the suit before Federal High Court, presided over my Lord Justice Omotosho. Now, upon their defection, to those of us who believe that Section 109 is self-executory, we held and still hold the view that they lost their seats. The Chief of Staff now, his name Edison, came into force upon the order of court. This set of persons haven't defected. They were remaining only 5 members of the House who never defected and in law seemed to be the valid members of the House. And so the court agreed with them and gave them the order to go ahead and function in that capacity. And upon emerging as the Speaker of the House, he activated Section 2 of subsection 2 of Section 109, declaring their seat vacant. And so if that decision is reached one way or the other, and assuming the court agrees that indeed there was a defection, and that defection was not in compliance with Section 109, subsection 1G of the Constitution, what is the status of these persons, again, in instituting this action, and to what extent is the benefit of the decision of the Court of Appeal yesterday?
Right.
Because they have lost their membership. And therefore, the issue as to whether or not, as at when he initiated the action, he was still the Speaker of House of Assembly.
Who was still the Speaker of the House of Assembly?
As to when they instituted the action. He, claiming that he was the Speaker of the River State House of Assembly, agreed, but upon defection, losing your seat, do you still maintain that status? So that is the question that, to me, I've looked at all these and I've come to the conclusion that the celebration is, I would like to use some certain words, it's just going to be short-lived.
Right. All right. Before I come to Barrister Ndamzi, I still have questions to ask you with regards to what you said. Now, you recall when we were on the first conversation, you said, Barrister Jamala, that when it comes to issues of states, like the appropriation bill, it is a jurisdiction of the state high court to
legislate over it.
However, when it comes to the seats of the members of the State House of Assembly,
determination as to whether or not.
Yes, you said that it has to do with the Federal High Court has the jurisdiction over state high courts in that regard. However, you recall that Edison here's, will I say, authentication or declaration in this instance as a Speaker of the fractional Speaker of River State House of Assembly was done by a state high court, which by his explanation does not even have the jurisdiction to even handle that matter or declare him the Speaker.
The court.
When it still boils down to jurisdiction.
Are you done?
Edison here was, will I say or use the word authenticated? No. Edison here was declared Speaker of the House of a fractional River State House of Assembly by a state high court.
No, that is not true.
Which Federal High Court?
That is not true. Not
which justice?
The court.
Which court?
The court, River State High Court, did not declare. Let's get it right. Did not declare Edison Speaker.
What happened exactly?
The court only approved their sitting. The court only asked that they are members, valid members of the River State.
State High Courts have the jurisdiction to approve.
I'm coming.
Plenary of a state high court.
Whether this court has jurisdiction or not is a subject of an appeal.
Hold
so
on.
Let's not go into that.
So if you say that is a subject, it still boils down to the question I want to ask. You just let me to the next question.
Yes. Let me answer the first one now. Allow me to land.
Okay, go on.
The court never declared Edison Speaker. The court only approved that upon the defection of these persons, you people are valid members of the House, rightly or wrongly.
That still boils down to the exact question I asked you. Does a state high court even have the jurisdiction to even handle that matter and say upon the defection? Does the state high court have the jurisdiction to determine the defection of state houses of assembly?
Where a court?
We are still boiling down to now.
Where a court errs in law. That is why we have.
Secondly,
yes. Let me ask.
If there is a proviso.
To what?
If there is a constitution and under that law,
yes,
there is a proviso.
Yes.
Who determines whether the proviso is or let me rephrase it? Is it not the court that will determine
precedent?
Yes, whether the conditions of the provisos were met or not, particularly if it is under contention?
Why we await the decision of the court in that regard? Shama, it will not stop me from thinking and believing so. That
however,
I'm coming.
However, court has already said
a court has
Martin Samehule remains.
That is on one bread. There are two different suits.
And you have said yourself.
Yes, there are two different suits. Shoma.
You have said yourself that.
Yes.
When this suit was instituted by Martin Samehule,
yes,
one of the prayers was that the court, the Federal High Court, should declare him speaker or authenticate his speakership. Martin Samehule should be, his speakership should be authenticated. Now, the River State government responded and did their own counter affidavit and all of that. And in that counter affidavit, of course, by that time, they have already defected. And accusations of those defections would have been included in it. Question is, why withdraw? So if the state government willingly,
let's not go into
willingly,
that.
It is immoral. You can't take it away. If the state government willingly withdrew that counter affidavit.
Let's not go into the fact of the reason.
Are we not back to status quo?
I'm coming, Choma. Let's not go into the reason why they withdrew those things. You and I know.
Question.
If I decide to,
the question is
to my father to take a particular action,
you're being sentimental.
I am not.
You are looking at the fact.
I am not. It is the understanding of sentiment.
Hold on. The question, I am not asking.
You use the word willingly withdraw.
I am not. They withdrew willingly. There was no gun to their head, because the governor as well chose the other items in the peace pact. He refused to.
But they withdrew all the actions.
So hold on. The governor also, in the peace pact that he signed,
yes,
there were also other conditions in the peace pact.
Like
he did not. Hold on, Jamala. Hold on. There were also some other conditions in the peace pact. He willingly decided not to obey, and heavens did not fall.
Like which of them? So I want to know which of them, because
Jamala, I won't let you play that game. You not deflect.
No, to my own understanding,
the question I want to ask you is this. You said defection was not part of the prayers initially.
Yes.
However, as at the time this Martin Samehule had already defected.
Yes.
And the River State government also submitted their own counter affidavit, and also part of all that was allegations leveled against Martin Samehule was their defection. However, River State government, for whatever reason, willingly withdrew their own counter affidavit and withdrew themselves from that matter, and judgment was given. If they had withdrawn that allegation and subsequently the governor still related with Martin Samehule, what does that say? So when you say that you don't want to, it is all embroiled, because we are back to status quo. So the government on one hand,
can I talk now?
Yes, you can, but the government on one hand cannot, by their own sentiments, set the law aside over a matter that they have willingly withdrawn and said,
you are beginning to turn to,
and on the other hand,
rather than a moderator, you are beginning to dance into the arena.
However,
ask me the question and I will answer you.
However, present it.
Don't dance into the arena.
No, hold on. However, you will not teach me my job. I will do it the way I want to do it.
I agree, but let it be seen that you are moderating.
I'm not exactly the regular moderator you see. This is Laurentia, and this is my modus operandi.
Okay.
As long as it gets you to talk, which you're doing already. So now, at the end of the day,
yes,
the government willingly withdrew. And when the matter did not favor them, the government is now saying they are not known by the law.
Yes.
But the law is saying that Edison here is not known as the speaker. So Jamala, make it make sense.
Yes.
You're not confused.
The government is not confused. Please.
So what's going on?
Although the matters are collated, there are two different suits. Let's get it right first.
All right.
The one that was, the judgment was given by Omotosho has to do with relationship with the executive and the ones pending at the Rivers State High Court Judicial Division has to do with defection.
Why did Justice Bassam recuse himself?
What?
Why did Justice Bassam?
There are several suits. Even there, one of your report talking about local government law extension.
Why did Justice
I'm not aware
Bassam,
if you can educate me.
You know, I find it very, very, very interesting that you choose what to remember.
I am not an
We have discussed Justice Bassam on my show, and you were a guest.
I am not encyclopedia.
So you don't know why?
I'm a human being, and my memory could fail me also.
And interestingly, you remember all the sections of Nigerian Constitution.
I don't remember.
But you do not remember.
I know the one that
you do not remember
discussions.
Oh, that's it. So are you saying?
I do my research before coming.
Are you saying you don't know?
Can you remind me what?
You don't know why Justice Bassam recused himself?
I want to know why Justice Bassam recused. In which of the matters?
I will find out.
I'm aware that Justice Nwogu declared dismissed one of the suit for lacking jurisdiction. I don't know of Bassam. If you can remind me, I will attend to it. But let's please. You are always deviating. The facts are different facts. One has to do with relationship with the legislature. The other one has to do with defection. And I said this suit predates their defection. Assuming they were right, which I agree to some extent, that assuming we are members of the House, can the governor stop to relate with us? Rather relate with some set of persons? That was their grievance. And if the court says no, the governor is wrong, then God, please mandate the governor to do so.
Which they did.
Which the court did. I am coming.
Go on.
The issue of defection has not been decided.
By who?
By the court.
Which court?
The Federal High Court.
Of which judge?
Obile Court 1 and Court 4. It started with Court 4.
Instituted by who?
Instituted by some members of Rivers State and civil societies. It's pending. Are you not aware?
Are you aware?
Are you aware of those pending
cases? Are you
cases?
aware of cases that were thrown out at the Federal High Court on the ground that the people or the appellants do not even have locus to present that matter?
It is not even the Federal High Court. It was the State High Court. That is the Wogo brought by Rivers elders. That's Justice Nwogu, not Federal, not what do you call it? Federal High Court. The Federal High Court has not decided. If my colleague is here to lay credence to that.
Ndamzi, do you know why Justice Bassam recused himself?
Yes, of course.
Go
Bassam did not recuse himself.
Did not. He gave a judgment.
Struck out the matter. That his court doesn't have jurisdiction to entertain any matter related to House of Assembly thereto.
And Justice Bassam is of the State High Court.
Yes, of course. That is the position of the law.
Do you recall what he said with regards to the defection of the lawmakers?
He said that their defection is unknown to the law, and that they still remain valid members of the PDP. That was, although that was a ratio, an obiter. You know, it wasn't a ratio. Yes, he just is a judge while delivering a judgment. Yes. So on this discussion so far, the AG saying the seats of the 27 members of House of Assembly remains vacant. I think I respectfully, I will differ with the AG completely here. Why do I say this? I want to cast our mind back to why Edison went to court. Because my colleague made mention of the fact that the matter predates the defection. I want to disagree with him. The matter never predated defection.
The one decided by Omotosho?
No.
That is the matter I'm talking about. The
reason, no, I am referring to the reason Edison went to court.
No, I'm not talking about Edison going to court. I said the matter presided over by Omotosho predates their defection.
Okay. Edison went to court and Justice, what's his name? C.M. Wale. Okay. C.M. Wale recognized the Okojombo-led assembly. All right. Edison went to court. And if you look at the Court of Appeal judgment, the previous judgment, that judgment, the Court of Appeal in saying that Edison never existed as speaker in the eyes of the law, and that all acts and omission done by that assembly was null and void. That is to say, including the appropriation that Edison approved for the governor, null and void. That is to say, all actions of Okojombo and his team, including the clearing of commissioners, SAs, clearing of the illegal caretaker committees, were all null and void. So, if the Court of Appeal, in their wisdom, could have declared actions of a purported speaker whom the government is recognizing and void, so what do we think in the eyes of the law will stand? Now, in reconciling the current position, I reiterated where we were talking of on the first topic here, the affidavit deposed by Martins and Co. One of their prayers in that suit was that the court should authenticate his speakership. So, during their matter, and the court went ahead and gave that judgment in line with the prayers of Martins. The court authenticated.
I remember I said
no,
it was. The issues of defection was never decided by Omotosho. True or false?
See, listen.
Was it decided by Omotosho? The issue of defection, whether the legality or not, was it defected? Was it attended?
Do not forget that in every matter before the court, before the court, these matters have different facts in issue. Okay. Point. Now, in Amehule's affidavit, it was very clear. Amehule is saying, court, declare my speakership authentic. The court in its wisdom have gone ahead to say Martin's speakership is the rightful speakership of the House. And no, not in assumption. The court of appeal was very clear in stating that. And that the position of the 27 members are clear. They remain the valid members of the House of Assembly.
Does that settle the issues of law with respect to defection?
The question
of law
of defection.
Yes.
The question of defection, the Supreme Court will settle that.
It has not even gotten to the Supreme Court.
The Supreme Court will settle that. I am very aware that the Supreme Court will consolidate all the House of Assembly matter and come up with a position. But so far, the courts of appellate jurisdiction have recognized that Martins, on the final judgment, it was a declarative judgment. Not a declarative judgment.
No,
unfortunately, we are out of time.
Chama, we still have some time, and I need to respond to some of the things they have said.
You have to do that in
at least 2 minutes.
No, 2 minutes is
but you gave me more than 10 minutes.
It was his turn to speak. I equally rationed it. Actually, he had less.
The Court of
Appeal in a minute
confirmed their interlocutory applications, agreed. But that is not the final. Remember I said, while appealing the judgment of court, and if I seem to be instead prohibited by the court below, I hold no contempt of court. That is the law. I end there.
All right. Final statement in 30 seconds.
Yes, in my final statement, I will advise the Rivers State government to maintain status quo. The Rivers State government should recognize, they should maintain the status quo by recognizing Martins.
That is not the status quo.
That is the status quo.
Thank you so much for coming.
But they need to do so.
If they do so, they will lose the right of
Barrister Jamala, you are learned, correct? Act like one right now. Thank you so much for coming.
Thank you, Chairman. Thank you.
Thank you for coming.
for having me.
It's a pleasure having both of you. And this is where we wrap it up on this episode of Open Conversation. We are open for advert placements, bookings, and commercials. You can connect with us on all our ATN socials: Facebook and YouTube, Atlantic Television Network; Instagram and TikTok, Atlantic TV Network 1; and on Twitter, Atlantic TV Net. Watch us live on our website, www.atlanticnetwork.tv. Do not forget, peace and unity are the pathways to progress. Thank you for watching. I am Ogu Laurentia. Transition News comes up next. Do not go away.
People are on the sea.
I will place economic stability and confidence.